It can be scary to share your diagnosis with your employer. Generally, you do not have an obligation to share your diagnosis with your employer if you don't want to. Your medical information is confidential unless you work in a safety-sensitive position, such as a police officer or firefighter, commercial pilot, or train conductor. Even then, disclosure would only be required in certain limited circumstances. However, if you're able to do your job without accommodations, which would be something such as a special break, extra permission, a workplace layout, time off for medical appointments, for instance, even pre-diagnosis, if you don't need those accommodations, you might choose not to disclose at all. However, you are also legally protected if you do choose to share that you or a family member has diabetes. You may also choose to disclose your diagnosis with your employer if you require accommodation. You shouldn't fear disclosing your diagnosis because the very purpose of human rights legislation throughout our country is to protect you from discrimination, including in the workplace. You would also be protected regarding most family members through human rights limiting discrimination on the basis of family status. So helping out a family member is absolutely okay. And this would include supporting a diagnosed family member as well as someone who is in the process of potentially being diagnosed. However, accommodation does not require your employer to pay you for time off. It merely lets you take the time off. So be aware that this time might be unpaid. If you do require accommodation, it's best to discuss with your employer so that they may accommodate you. In these times, it's best to emphasize what you can do. It sometimes helps to have a medical note that outlines your requirements. Your rights are guaranteed by various human rights legislation that exists throughout Canada. Human rights legislation exists at all Canadian jurisdictions, the federal, provincial, and territorial jurisdictions. So every part of Canada is covered. Under the Canadian Human Rights Act, it is discriminatory to refuse to employ or to refuse to continue to employ an individual with diabetes. You have the right to accommodation in the workplace up to the point of undue hardship. Undue hardship is not an easy test for employers to meet. It is a demanding obligation that requires employers to assume substantial extra obligations and financial costs. It is not a matter of whether it is good for their business or whether they want to do something. It is a legal obligation. Note that your employer cannot contract out of the duty to accommodate you. You can't sign away your rights, in fact. That means if you sign any contract that limits the employer's obligation to accommodate you, that contract is very likely unenforceable in law. Forms of accommodation that a person with diabetes may wish to request in a workplace include some examples like a private area to check your blood sugar or to take insulin, a place to rest until blood sugar levels become normal after treating low blood sugar, a place to store food or medicine for the treatment of hypoglycemia and low blood sugar, and time off to attend medical appointments. It is, however, important to note that merely because you are being accommodated does not mean that your employer cannot terminate you. Most non-unionized employees can be terminated at any time for any non-discriminatory reason. However, if you are terminated for a discriminatory reason, then you can make a claim to an appropriate human rights tribunal. If your needs are not being met, you should consider filing a complaint. Many complaints can be dealt with by human resources or a manager in charge of your area of work. However, if that does not work, then you may need to make a formal complaint to the government. Before submitting a formal complaint, it is best to speak with a human rights lawyer to assess the strength of your case and to be informed about what the procedure might entail. Where you file the complaint will depend on which jurisdiction applies. For instance, if you are federally regulated, someone working at a bank, as an example, you should file a complaint with the Canadian Human Rights Commission. If you are not federally regulated, such as workers at a corner store or an accountant's office, then you would make your complaint with the respective provincial human rights tribunal, for instance, the Ontario Human Rights Tribunal in Ontario. Each province has its own human rights tribunal. You should be aware of the statutory limits for making a complaint so that you don't wait too long. For example, under the Canadian Human Rights Act, a complaint must be filed within 12 months of the event being complained about. There are other avenues you can also take outside of a formal human rights complaint. For instance, in Ontario, courts have jurisdiction to determine remedies of the breach of the Human Rights Code as long as the action is not solely based on a code infringement. What this means in practice is that if you've been terminated and your diabetes or the diabetes of a loved one played a role in that termination, then you can sue in court for wrongful dismissal and seek human rights damages before a judge of the Superior Court. Additionally, persons who are bullied or harassed in the workplace because of their disability might amount to a constructive dismissal. You might be able to sue for human rights damages as well as for severance pay relating to you being effectively dismissed from your job due to that bullying or harassment relating to your diabetes.